Already,
There's a PO and there's an application for stay.
yeah, POs are never listed for hearing. What is coming up for hearing is our application dated the 17th of February 2025. That's what was certified and fixed for hearing today. It is in respect of that application that there is a PO.
Can you then hear the application? After the PO, if you still want to proceed, it can be urged when you're responding to the application. This is an application of the stay of exception of Judge Sifuna is ruling dated 16th of December.
Yes, that's the one, Malay.
Which dismissed the petitions.
It dismissed a request for leave to appeal out of time and an application for stay.
So Mr. Havi, if I understand,
Yes, my lord.
you are footing in this court for purposes of an application for stay is the notice of appeal against the order of Justice Sifuna of 16th December 2024, right?
That's right, my lord.
Which dismissed your application for extension of time for to apply for leave to appeal.
That's the one, my lord.
And therefore, what you are trying to say is actually not the decision of Sifuna, Justice Sifuna, but the judgment itself that was entered against your client.
No, my lord. I'm quite specific on what I want. Subsequent to that dismissal, there will be proceedings to execute. Those are the ones we need to stop.
You need to stay.
We are staying subsequent proceedings subsequent to the delivery of that ruling.
Okay, let me just have this clarified. If Judge Sifuna dismissed the application for leave to appeal,
Yes.
it therefore means that without leave, we do not have a valid appeal before this court.
No, the request he dismissed was for leave to appeal from the Deputy Registrar to the High Court.
For the costs, okay. All right.
Yeah, but we have filed a notice of appeal from his decision, which we are entitled to as a matter of right to this court.
Okay.
So still, Mr. Havi, it's not clear to me. So what are we saying? And what's the connection of what you are saying, what you are seeking to say with the decision of Justice Sifuna of 16th of December?
Thank you, my lord. This is the point. Judgment was issued for interest to run with effect from February 2008. The Deputy Registrar erroneously signed a decree for interest to run from February 2003. So when we sought to have that issue rectified, the learned judge of the High Court said, no, you can't review, you ought to have appealed. Look, I mean, is that ridiculous? The decree...
No, please, Mr. Havi, let's not go there. Let's not go there. You may disagree with that decision, that not quite ridiculous, eh?
No, it is.
If you explain what that connection I'm asking, because you are getting on it.
Okay, so the connection is this. Having refused, because the judge said you ought not to have applied for review, you ought to have appealed. So we went and did that which he said we should do. But because time had lapsed, we applied for leave. And then what he did was say, okay, fine, you had come for review, so you can't come for appeal. So I will dismiss your application. I mean, sorry to say, I don't know how else to explain it in English.
As you look for the English words, Mr. Havi,
Yes.
let's confirm that this application is the one dated 17th of February?
The one before you is 17th of February.
Yes. And the one dated 17th of February, the relevant orders, prayers now, is maybe prayer prayer number 2, which is asking for stay of execution of that ruling. It's a ruling that is a dismissal. Yes, I think it's the same one as the prayer number 3.
Yeah, 2 and 3 will be the substantive request.
There's a prayer also. 2 prayers. Sorry, sorry, those are not the prayers I'm looking at.
I think number 4 must have been drawn in.
Prayer number, just allow me. That is prayer number 2. You're asking for state pending hearing and determination of the application interpreted. Okay, we are hearing it now. Determination. And the alarm is pending determination of the appeal. What I was saying is that ruling of 16th of December actually dismissed your applications. Prayer number 4, you are asking us for orders that we are not very familiar with. You're asking us to investigate what are the investigate. But what I'm trying to say is that to make it clear is that your application for stay is a stay of negative orders issued by the
Now, my lady, I think we're dwelling on technicalities. We are living in the 2010 Constitution. The dismissal of this, just a minute, my lady, I'm entitled to speak. I've filed an application, I've put submissions, permit me to argue my application, you can write your ruling. Because this is the same strategy adopted by the High Court judge. There is an error manifest on the record. So allow me to argue my application, you'll write your ruling.
We shall application, Mr. Havi, that is why we are here. May I also point out there's another application presented today. I don't know whether it has a hearing date for
no, that application has not been fixed for hearing today. It's not even been certified urgent.
I'm just trying to get information.
What for?
My goodness. I was just confirming there's an application for striking out, which has been sent to us, and I wanted to find out the status. Don't ask me what for. I have a reason why I'm asking.
I would agree with it's coming. Injunction. Yes. I mean for stay of execution, not injunction.
Yes, my lady, let's hear the one that is listed before us today.
Yes, I'm just confirming that they have filed the applicants have filed their submissions and stay. We have the record of appeal and all the other documents. I saw the application for the PO. The respondents have filed their submissions, replying accusations. Yes, so Mr. Harvey, how much time do you need to highlight your submissions?
10, I may be, sorry. 10 minutes, I may be less.
We do not give 10 minutes for highlighting of applications.
How much will you give me, my lady?
You actually give 5 to 7 minutes.
7 will do.
You can start now.
My ladies and my lord, before you is my motion dated the 17th of February. The substantive and ultimate relief sought is stay of proceedings and consequential order subsequent to the ruling delivered on the 16th of December 2024. At the onset, may I indicate the appeal itself has been filed, being Civil Appeal number 110 of 2025. This motion is filed within that appeal. We have filed our submissions. They are dated the 2nd of April 2025. The arguable question upon which we hinge an appeal is the determination by the trial judge that he could not entertain an application seeking leave to appeal out of time and to grant stay for the reason that the appellant had already exercised the right of review and there was inordinate delay. But what are the facts? The facts are this. In the judgment delivered by the High Court on the 10th of November 2016, interest was directed to accrue from February 2008. The Deputy Registrar erroneously drew the decree as February 2003. The respondent has been paid the entire decretal sum on the computation of the interest with effect from February 2008. But what the defendant was pursuing before the High Court was to execute the erroneous decree. So faced with this scenario, the judge dismissed a challenge to the attempt to execute on the erroneous decree, holding that we need to file an appeal from the error of the Deputy Registrar. But when we eventually filed that appeal out of time, not occasioned by any mistake on our part, the judge again said, you are out of time, and having applied for review, I cannot entertain this application. That point is arguable. Why will the appeal be rendered nugatory if stay is not granted? The defendant has been paid in full, yet it wants to execute on an erroneous decree. With tremendous respect, my ladies and my lord, this is not an issue that the judge of the High Court ought to have countenanced on account of the technicalities he proffered. Sorry to say, it is egregious. The interest of justice cannot be defeated in the manner in which the respondent wants to do. It is therefore a humble request that an arguable appeal has been made. The appeal will be rendered nugatory if actions and decisions consequent to the ruling of 16th December 2024 are not stayed. And there is no prejudice to be suffered by the defendant. They have been paid in full. They are relying on a technicality to unjustly enrich themselves. That is wrong. It's deplorable, and this court must halt it. That's all I ask of the court.
Mr. Havi, Rule 52B give your client the option of actually applying for stay of proceedings or even for an injunction. But you deliberately choose to come for stay of execution, right? So when you're talking about the court being obsessed with technicalities, why didn't you seek stay of proceedings or an injunction to stop whatever you're complaining about rather than stay of execution? Because your application is very, very express. You're seeking to stay execution of the decision of Justice Sukuna.
Two things, my lord. I've been instructed to lead counsel in this matter, but that notwithstanding, my reading of prayer 3 is any other consequential orders following from that ruling. I mean, what is in a rose if that which smells like one by any other name will be called a rose? We want to stop consequential proceedings. And I think you've asked Attack an appropriate question. Why are we splitting hair? That's my answer to your question, my lord.
Mr. Havi, it's very clear here. You are reading somebody who drafted the proceedings badly, but really instead of shifting blame to the court and all this, yeah, you need to own up that there's a problem there, or you have.
Okay, let me be forthright. There is no problem. Our request is to stop consequential orders.
All right.
Yes. Let's not cut around the bush. So allow me to respond on the legal issues.
Mr. Havi, we are putting this question directly to you. There's nobody who is cutting around anything, yeah?
That's okay. Can I give my response to Mr. Attacker?
So if you are just talking about consequential, sorry, Mr. Havi, I didn't get you.
I requested to be given my right of reply, 3 minutes to Mr. Ataka.
Just a minute, Mr.
No, but you are clarifying the questions before you respond to Mr. Ataka, please.
That's okay. That's okay. I thought I'd said so. My Lord, why are you being very antagonistic? Can we just have a civil
I think that Havi,
Mr. Havi is being extremely unusual and antagonistic.
You are the one who came with that, and we have no problems with anybody.
No, my lady Justice Karanja, you've always had something against me. I know you very well. Yeah. So let's not go there.
Please, let us find out from Judge Achode if she has any comments, and then we'll give you a right response to Mr. Ataka's address.
My lady, I cannot respond because today I don't know what is happening. This back and forth is not so good. Can't respond. I have no question for him.
Okay, you have 2 minutes to respond to Mr. Ataka's address, Mr. Havi. Then you can give you a date for ruling.
So 3 points. Mr. Ataka has not addressed the agreeability of the appeal as proffered by myself. Instead, he has again dwelt upon technicalities on documents he alleges have not been included in the appeal. We are not here to argue the appeal. And fundamentally, we are not arguing the application to strike out the record of appeal. But more importantly, any challenge to the propriety of a record of appeal is one that must be filed formally under Rule 84 and within 30 days. This appeal was filed on the 3rd of February 2025. 30 days expired on the 3rd of March 2025. That application which he alludes to was filed on the 4th of April. Those technical arguments cannot dislodge a very cogent case that we've put before the court. We humbly request that you grant this application in the manner sought. Thank you so much.
Arnold, 25th July, is it?
Yes, my lady. 25th July 2025.
25th of July.
We are most obliged, my ladies and my lords. Thank you. Have a good day. Mr. Ataka as well.